Good morning, Ms. Hassim. Good morning, Mr. Premhead.
Good morning, Chair. Good morning, Commissioners.
Thank you.
Morning, Chair. So before we begin with the witness today, we have one matter to deal with.
Yes.
And that is Mr. Carrim's appearance.
Yes.
And I'll let my learned friend, Mr. Premhead, begin.
Yes, Mr. Premhead.
Chair, I'm hoping that you and the Commissioners have the latest bundle which was provided to us this morning by the Commission, for which we're very grateful. But at paginated page... paginated page, the correspondence starts at 210, but the medical report in question itself starts at 212. I hope you have it. I'm seeing indications you do have it. I don't want to read bodily or facial expressions.
No, the minute you opened your mouth, my colleague Commissioner Kumalo said page 212.
Okay, perfect. I'm indebted. I'm also not sure if the commissioners have had a chance to consider the content of the report. I'm seeing indications there have been. And effectively, may I just ask you if you've got that report in front of you, to turn, and I'm going to take you to the end if you don't mind. I would take you to paragraph 20 at paginated page 225 of the bundle. Thank you, Chair.
Thank you.
And I point out that paragraph for two reasons. The first one is that gives you the state of Mr. Carrim. And secondly, it then explains what has transpired or not transpired since the ruling of the 29th of July and why we are here in the way we are here. And I don't know to what extent I need to say anything more than that, but obviously I'm in the Commissioner's hands as to whatever issues might arise as a result of this report now being in front of you.
Thank you, Mr. Premhead. Do you wish to say anything, Ms. Hassim?
Thank you, Chair. Chair, what I'd like to do is just to, for the purposes of the record, explain the steps and efforts that were taken from the Commission's side to give effect to the ruling, and then to come to where we are now, and what I propose we do in these circumstances. So if I can begin with the ruling. The ruling is quite clear, the ruling of 29 July. In clear terms, what it says is that Mr. Carrim is required to appear and to testify today, and that he may only do so if he is excused on the basis of an independent medical assessment.
He may only not do so.
He may only not appear.
Yes, you left out the not.
Thank you, Chair. So he may only not appear today on the basis of an independent medical assessment, which was to have taken place by the 12th of August. Immediately following the ruling, the evidence leaders took steps to obtain the names of suitable independent specialists who could attend to the task. We provided the name of such a specialist to Mr. Carrim's representatives the day after the ruling, that's the 30th of July. On the 31st of July, we received a response from Mr. Carrim's attorneys saying that they had forwarded that information to the family and to the treating doctor. You'll recall, Chair and Commissioners, that the ruling required that if there is no agreement on the proposal from the evidence leaders side, by the 3rd of August, that then the president or the chair of the professional association should nominate an independent specialist. So we heard nothing further from Mr. Carrim's attorneys. And so we wrote again on the 3rd of August, the deadline, requesting a response by 10 a.m. on the 4th of August, especially a response as to whether Mr. Carrim has consented to an independent medical evaluation, because we were concerned with putting things in motion and putting people out unnecessarily. We also indicated in that letter of the 3rd of August that if we didn't hear back from them by 10 a.m., that we would then contact the president of the association in order to set things in motion. No response was received on the 4th of August. We approached the president, who nominated a specialist. And we thank the president of that association for responding to the commission's requests with urgency, and providing us everything that was required. And we regret if there was any inconvenience caused. The president provided us with the details of the independent specialist. This was communicated to Mr. Carrim's attorneys on the 6th of August. It was only on 12 August that the evidence leaders received the treating doctor's report, the report that Mr. Premad has now referred the commission to. And so the report provides to us, for the first time in this process, a detailed explanation of what is said to have occurred following the ruling on the 29th of July. Whatever may have been occurring between Mr. Carrim and his family and the treating doctors, none of that had been communicated to the evidence leaders while we were attempting to give effect to the ruling. The report essentially is an opinion by the same treating doctor as to why Mr. Carrim could not consent to an independent medical evaluation, and it provides further material information regarding, clinical information regarding his condition. Notably, it says nothing about the outings that we referred to in the postponement application, the daily outings by Mr. Carrim. There is reference to the 14 July excursion to Woolworths and to Kauai, but, and that's for the purposes of complaining that it had become public, that it had been made public.
Is the answer to that not possibly that that was dealt with within the postponement application, even by the treating doctor?
Well, it wasn't dealt with in depth by, it wasn't dealt with from the perspective of what the meaning of that is for Mr. Carrim's inability to testify now. And that's what we are concerned with now, is the current condition in the light of these daily outings. I would have expected that that would have been addressed more fully, given that it was a significant aspect of the, from the evidence leader's side, the opposition to the postponement application. But that's not the main, that's not it. The problem, the difficulty we have also with the report is that it's a lengthy report that's furnished 2 days before the hearing without any opportunity for the evidence leaders to obtain a considered expert opinion upon, expert opinion of the contents of the report, right? As the Commission is aware, there is an independent specialist that the evidence leaders have consulted and would have otherwise wanted to consult on this. But the report is expressly marked strictly private and confidential, medical privilege invoked, not for dissemination, and that it is furnished strictly and only for the consideration of the chairperson, commissioners, and the evidence leaders. That places us in a difficult position because it's prepared at a level of clinical detail, and it says so. The doctor this time says the last reports were for a layperson. This report, he says, is prepared at the level of clinical detail that's appropriate for consideration by a medical professional, But the restriction that's imposed upon its dissemination makes it impossible for us to obtain, for our own purposes, any independent assessment from an expert of that report. So where we find ourselves now is in this circular process, and we keep going around the mulberry bush with respect regarding this witness. And at the time remaining for this commission, and this is the submissions I'd like to make on how we'd go forward, Chair and Commissioners, there's limited time remaining for this commission to complete its mandate. At this point, we submit it's appropriate for the commission to simply make its findings based on its assessment of the evidence that's already before the commission. In the previous hearing at which Mr. Carrim was present, and the evidence that's been provided, and also, for that matter, on the basis that there's certain information that has still not been furnished. The Chair is now familiar with the basic information that we've requested on just financial statements. That hasn't been forthcoming in the interim since the postponement application either. So what we would submit is that the Commission now just makes its findings based on the evidence that it currently has before it, without any further...
What kind of findings do you have in mind? I'm sure you are not referring to the postponement application because the ruling on that application was made on the basis of what was before the Commission at the time of the hearing of that application. So what sort of findings do you have in mind?
Chair, I'm referring to any findings to be made on the basis of the evidence that was led on the 9th and 10th of March. So it's on the merits of what the issues are, whether it shows any of the conduct that we were presenting at the time that we felt fell within the terms of reference of the Commission.
I hear you.
So it's those findings. So the evidence we have is the evidence we got.
Yes.
And let's live with that, is what I'm proposing.
Yes.
But
and what is to be done about the issues that the evidence leaders considered to be still outstanding? There's nothing that can be done in that regard. Conclusions will just be drawn in whatever way regarding those outstanding issues.
Yes, the witness hasn't been able to make himself present to address any of that, and the Commission should follow the normal course as it would in any other hearing, in the absence of answers to draw its conclusions.
So if the outstanding matters tell an adverse story on their own without anybody speaking to them, then the Commission may draw whatever inferences in that regard.
Indeed so, Chair. That would be the normal course in any hearing, even in a court. So that's what we propose should happen going forward, except for the following, which I'd like to add as my final submission, and which is that we do request that the Commission records the non-attendance and refers this non-attendance and the record to the NPA or the relevant authority for further consideration for potential breaches of the provisions of the Commissions Act and the regulations. Chair, and the reason for that is that the Commission, through its ruling, has given Mr. Carrim a fair and objective route to establish medical unavailability. He chose not to opt for that route. The ruling is clear that the witness may only be excused on the basis of an independent report, and we don't have it. It's not a finding that's going to be made by the Commission. It's a finding that will lie elsewhere, but it needs to be referred to the relevant authority for potential violations of the Act. Those are my submissions, Chair.
Thank you, Ms. Hassim. Mr. Premier?
6 very brief comments in reply, if I may, please, Chair. The first one just relates to timing.